Good afternoon, everyone, and welcome. I'm Jo Campbell. I'm the manager for our VWV Approach Network. So I've had the pleasure of meeting many of you, although there are some names on the list today where I don't believe I've yet been able to meet you in person. I was going to say you've joined the meeting on mute, but I can hear somebody in the background. So you are all muted currently. As the session progresses, we are holding it in meeting format here on Zoom. So as the session progresses, and Shivaji, our speaker today, is running through his slides and his background to the topic, you will have the opportunity to unmute yourself and ask a question if you'd like to. Alternatively, for those of you who haven't used Zoom before and may not be as familiar with its functions, at the bottom of your screen, there ought to be a bar including a chat function. So if you'd like to ask a question as we're going through today and don't want to unmute yourself and ask in person, do feel free to pop that in chat. You have the option to ask the question to be visible of everyone on the call, or perhaps send it to me personally if you don't want your name to be visible to the other delegates. And then I can ask that question of Shivaji. So we're doing a charity law update today. It's the first time we've done one through VWV Approach Network. Charities is one of the sectors in which VWV is pretty well known. I believe the team is 24 strong now across all of our locations, working with everything from small community-based charities to extremely large ones on everything from formation to disputes to governance to trading. Shivaji knows far more about the intricacies of what the team does than I do, so I'm sure he'll be touching on that a little bit more during the topic. Shiva, our speaker today, is a partner based in our Birmingham office. He has 20 plus years experience of working in the charity sector, particularly with faith-based charities and with federated charities. I think he will agree with me that that's one of his little niches. He's also a very avid cyclist, so involved in lots of local and national organisations that promote cycling activities. So today, Shivaji is going to do a fairly comprehensive run through of some updates of the charity law sector, including the impact of COVID, regulatory approach by the Commission. We are also looking at governance, some key cases, merger considerations, and what to do in disputes. So I won't dwell too much longer on the intro as Shivaji has got plenty to talk to you about. I will just say that slides will follow together with a recording of the session. So in the next day or two, we'll provide the update there. You'll also be invited to sign up to our charity law brief, where the team regularly send out newsletters on notable cases or changes in the sector. And right at the end of the session, there'll be a quick online poll for you to complete in providing your feedback on the session. So please do stay with us long enough to complete that. It really helps us in terms of planning for future events. But on that note, Shivaji, I will hand over to you to commence your run through of the legal update on charity law.
Thank you, Jo. Well, good afternoon. As you've heard, I'm Shivaji Shiva, a charity lawyer, a charity trustee, and a partner in the charities team at VWV. This session, as you've heard, is a legal update session. I'm going to cover the period since about late 2019. And you've heard a bit and you've seen the details of what the session includes, so I won't labour that just at the moment. What I will say is that capturing developments in the charity sector is difficult for reasons that will be familiar to many of you, particularly those of you who work with charities or who are yourselves charity trustees. The sector's enormously varied, and a comprehensive update on all the legal issues that affect charities would take a lot longer than the 60 minutes, including Q&A, that we have this afternoon. So one way of getting to grips with all of that variety is to focus on the numbers. And if I could have the next slide, please. Here we have some of those numbers. Again, some of this will be familiar to you, but this is the Charity Commission's annual report for the year ended 31st March 2020, which was published in July last year, and we might see the next one in July this year if they've managed to keep up the timetable, despite all that the last year has seen them having to do. During that last year, 8,329 applications were made to register charities. 6,046 charities were removed from the register, and we ended the year with a total of 168,033 charities on the register. And of course, if we include all of those charities that are exempt or accepted from registration, that figure is significantly higher, and higher still if we look at Scottish charities and those in Northern Ireland, which I'm not looking directly at today. In itself, all of this tells us very little, but it does make me wonder how those figures will be updated, or how they will look when we get updated figures in a few months, given the enormous pressures on the sector at present. If we look across at perhaps the same sector, but non-charities, we can look at the CIGA Regulators annual report. And that reveals that during the same period, we had 5,106 community interest companies registered and a 20% rise in the number of CIGs, taking us to a total of 18,904 CIGs on the public record by 31st of March last year, with about 20,000 by the end of October. So that number is obviously growing significantly. And those numbers led the CIG regulator, Kerry Richard, who stepped down September last year, replaced by Louise Smith, to observe that the CIG brand is continuing to grow beyond all expectations. And when community interest companies were originally established in 2005, it was anticipated that around 200 CIGs would be added to the company register annually. We're now receiving almost double of that in applications and are adding more than that amount to the register every month. He also highlighted the fact that co-ops, social firms, charities, ordinary companies and LLPs have also adopted or converted to the CIG model. I know that we see this in our work, and all of this says something about the strength of the CIG model and its enduring appeal. But I won't be saying much more about CIGs in this session. Most of the developments I highlight here will focus on charities. And that brings us to more numbers. The fact that we're delivering this session online rather than in person is a reminder that in the past year, the numbers I've just given you have been overshadowed by other larger and more tragic numbers arising from what has been the most significant event of the year for most of us. Next slide, please. So this again is a set of numbers. The COVID-19 pandemic has seen more than 500,000 cases in the UK. The worldwide death toll is now long past 1 million. It's difficult for any of us to conceive of 1 million people dying. Sadly, the tragedy is more immediate for many of us, and some of you will have lost friends, family members, or colleagues. Most of us have experienced the uncertainty and anxiety of experiencing symptoms or nursing a loved one through such symptoms. And it's impossible to look at the past year for charities without acknowledging the impact of the pandemic and how we're responding, and they've responded to COVID-19 and the lockdown. So it's strange to think just how quickly those changes crept up on us as a sector. From a situation early last year where COVID-19 felt like a distant issue, something that people on the other side of the world might be worrying about, but perhaps we didn't need to the massive uncertainty of March 2020, a period during which many charities reviewed and renewed financial forecasts on an almost daily basis while we established how long lockdown would last and how severe the lockdown would be, with many charities seeing income grind to a halt. They stopped operations or greatly reorganized them at short notice, watched out for changes in the law, which came frequently and often very shortly before they came into force, with guidance and associated regulations arriving at different times in a way that made it very hard for charities to plan and to implement the necessary changes. And of course, charities were managing all of this uncertainty on staff, volunteers, trustees, and donors. Another side effect, of course, was discovering that meeting by video link in the way we're doing now is easier than many of us thought, if surprisingly tiring. Within weeks of that lockdown starting, the Commission issued guidance on COVID-related issues back in 17th April 2020, so 7th April 2020, and those were updated regularly. They started by saying, we want to assure charities that our approach to regulation during this uncertain period will be as flexible and pragmatic as possible in the public interest, whilst helping trustees to be aware of and think about the wider or long-term impact on their decisions on charities. So trustees and leaders across the sector had to consider a range of issues fast. And in fact, when I talked to colleagues in preparation for this session about the developments of the past year, a common response has been to say that it's hard to think beyond the impact of the pandemic. Employment issues were, of course, key, though I'm not covering them in this session. Many of you will have been advising on the furlough scheme and the job support scheme, which replaced it last October. It became routine to see in daily news updates and legal briefings reference to redundancy programs at large charities, sometimes involving thousands. Now, if we return to charity governance, the sector was given some reassurance in the form of the Corporate Insolvency and Governance Act 2020, which received royal assent on the 25th of June last year and came into force the next day. Among other things, that provided some reassurance to some charities, the qualifying bodies, around two key issues: meetings and solvency. We take meetings first. An obvious impact, as we said, of COVID-19 has been the inability of trustees and members of charities to meet in person. And as we've seen, rules governing people's ability to meet have changed rapidly, and at a local as well as a national level over the past year. Now those rules, the lockdown rules, are loosening, of course, but not everyone will want to meet face to face despite that. At the same time, not every charity has authority in its governing document to hold meetings electronically. The Commission's pragmatic guidance that I just quoted from has been that if trustees choose to meet, to hold meetings electronically, and without authority in the governing document, the Commission would understand, but that trustees should record while they were doing this. And of course, in those circumstances, there was always the risk of dispute, perhaps because there's some contentious issue to resolve that meant that the pragmatic approach simply wasn't possible. An example could be seen in a case called Jaffa and Jaffa, which is a High Court case, the judgment from which became available just in the last few days, and which centered on, as many similar cases will do, the fact that the annual conference of the organization, its AGM, couldn't take place in person. And as a result, elections that were being, that took place immediately prior to when the AGM was going to take place, couldn't be considered by the AGM and implemented appropriately. Without going into the details of that particular case, it is, I suspect, going to continue to be an issue for organisations that decisions that were to be made at an annual general meeting during the past year were not made in person. And for some of those organisations where there were contentious issues, that's left quite important issues in abeyance for months. So as far as members' meetings are concerned, at least so far as companies, friendly societies, community benefit societies and CIOs were concerned, Schedule 14 of the Corporate Insolvency and Governance Act enabled meetings held between the 26th of March 2020 and the 31st of March 2021 to be held electronically, and for votes to be cast electronically. It also allowed for postponement of meetings within that period. It's important to note that this did not help unincorporated associations, statutory corporations, or charter corporations. It's also important to note that charities that took advantage of those provisions should now be considering a longer term strategy, and that may include constitutional changes if they have not had the opportunity to make those changes yet. So for those of you who are working with charities or are trustees yourselves, now would be a good time to be reflecting on what the governing document says about meeting electronically, and whether it is appropriate now to update those provisions, either to introduce the power to meet electronically, or to consider whether the practical arrangements around such meetings could usefully be improved and documented better. The second thing that the Corporate Insolvency and Governance Act gave some reassurance on was easing the pressures of insolvency. And that's included a number of helpful provisions, of which perhaps the most high profile was concerned with the exposure of directors of insolvent companies, including trustees of charitable companies, to wrongful trading actions. The Act provides a limited modification, not to whether directors were trading wrongfully, but to the court's approach to determining their liability. And in doing so, the court is to assume that during the period from the 1st of March 2020 to the end period now, June this year, I believe, the directors aren't responsible for a worsening financial position. Given the extent of the director's responsibility as compared to the impact of COVID-19 is likely to be an amply explored issue on liability as between directors and creditors, it's difficult to know what legal or practical effect that assumption is likely to have. But again, it provided some reassurance. And then another impact of lockdown that's worth exploring in this context is the execution of documents. And we saw during the past year some swift work done to ensure that documents could be executed even while social distancing measures were in force. And the land registry has been accepting electronically signed documents. Physical presence is still required for forms of execution which require witnesses, even if wet ink is not needed. But perhaps the biggest impact has been on those corporations that are not able to use the simple personal execution provisions available to Companies Act companies and are not in the special category of unregistered companies. As you know, charities which are charter or statutory corporations typically are not unregistered companies since those exist for the acquisition of gain. And the default position for those corporations is that the seal must be affixed in a meeting. Section 74 of the Law of Property Act 1925 offers protections for counterparties where the seal is attested by two members of the governing body. Sometimes charters and bylaws themselves make more elaborate provisions. Those charities all need to think about custody of the seal and how critical deeds can be executed if increased social distancing rules make these processes difficult again. So if we have another lockdown. New slide, please. So if we continue moving forward through the year that we've seen go by, at the point that some of us were beginning to adjust to lockdown, a further crisis of sorts took place. And on 25th May 2020, George Floyd died in horrifying circumstances, as we'll all remember. And in May and June, there were protests around the country. And the impact of this development in the charity sector is illustrated by the way Charity So White and similar campaigns came to the fore. In the weeks since then, many charity leadership teams have spent a great deal of time reflecting on inequalities in the charity sector and society as a whole. So there's been an effort to engage with issues of racism and other forms of discrimination through all of that. And I want to come back to that. But for the moment, new slide, please. So what I'm going to be looking at through this session is just summarised there. We've looked briefly at COVID-19 issues. We'll come back to that. But I also want to have a look at inquiry reports and Charity Commission regulation, case law, and at the effect of lifting lockdown in terms of charities thinking about building back better, as the phrase goes. So if we start with charity regulation and move on to the next slide, please. This is a reference to a new charity registration, the Public Interest News Foundation, and the Cairncross Review. The Cairncross Review into a Sustainable Future for Journalism was published in February 2019, so a couple of years ago now. Given the timing, you might expect that its recommendation, which was that governments give priority to exploring the development of tax relief, ideally under the Charities Act, to support public interest journalism, was a matter for last year's legal update, or even the year before, and this year's chip wrapper, as we might say. But the government's response didn't actually arrive until middle of last year. there was to be no new charitable purpose of public interest journalism. The government was satisfied that the existing framework of charitable purposes provided a set of appropriate options for public interest journalism. The Commission's guidance, captured in a blog in January 2020, highlights citizenship and education as potential purposes for public interest journalism, as well as highlighting the constraints of charitable status, including those relating to private benefit, to party politics, and around political activities. In September 2020, the Commission published its decision on an application by the Public Interest News Foundation, which illustrated how all of this would be applied in practice. And the organisation was registered under existing heads of charity, including essentially education, by analogy to earlier registered charities, the promotion of active citizenship and civic responsibility, and the promotion of high standards of ethical conduct and best practice in journalism and the editing of and publication of news. So essentially quite similar to the Independent Press Regulation Trust, concerned with promoting high standards in journalism and accepted as charitable by the first tier tribunal. Another judgment from the past year was that in the Theosophical Society, which where the Commission published belatedly its full reasoning for registration in 2016 of the Theosophical Society as a charity. And that also came through in September last year. And without going through that into detail, it's worth noting that the Commission had to consider whether it had jurisdiction to consider the Society's application for registration as a charity, and in particular whether it was bound by decisions that had been made previously by the court in 1931 and 1957. And as the decision that's available on the Charity Commission website records, the charity had made considerable changes to the way it operated since those earlier decisions, and the Commission concluded that it was entitled to form a view on whether or not an institution is a charity, even though the courts had previously made a decision in respect of the same institution, provided that there are circumstances which would justify reconsideration of the case. And the Commission concluded that it's well established that what the law regards as charitable may change with changing social and economic conditions, such that purposes regarded as charitable and beneficial to the public in one age may not be so regarded in a later age, and vice versa. An extract from the National Anti-Vivisection Society, which some of you will be familiar with. The Commission considered that the circumstances which might permit reconsideration of the charitable status would be significant changes in the legal framework, in the constitution and activities of the body concerned, or changes in social and economic circumstances and the general environment within which the body operates. And clearly the Commission decided in this case that it could proceed with the registration. It's worth, I think, just highlighting that where organisations have sought charity registration and failed or been rejected, that it may well be worth reconsidering that. And this is just a reminder of that fact. And in particular, I think we've seen faith organisations, particularly newer faiths, considering whether or not they can secure a registration. And particularly in the current environment and limited resources of the Commission, often the situation has been that they've made an application, perhaps two applications, been rejected, but they haven't given the application as much time and consideration as might be merited. So if you have an organisation on your books that has sought charity registration and failed to secure it, it might be worth reviewing with the client whether it would be worth taking another look at that. Next slide, please. So here I wanted to just highlight a few of the inquiry reports issued by the Charity Commission and their practical relevance. You've got a list of some of those published in 2020 there. And it's worth just trying to get a picture of what the Commission has issued. So from roughly October 2019 to September 2020, that year, there were 30 inquiry reports, with another 10 to follow later in 2020 and 7 so far in 2021. It's worth noting in passing perhaps that quite a number of those related to faith-based charities, and that there is at least a suggestion that that's slightly disproportionate. I know a number of the faith charities that I work with feel that it is more likely that they will see charity commission scrutiny. I'm not sure how true that is. I'm not sure that the numbers quite support that position, but it's not hard to see why they come to believe it. And it's perhaps an argument for saying that if you run a faith charity, and particularly a complex faith charity, that it's worth putting more effort into ensuring that governance is absolutely unimpeachable, so that you avoid giving the Commission or anyone else the opportunity to question the way in which the charity is run. And looking at the updates on inquiry reports that we issued over the past year and a half is a reminder of just how different the world looked in the autumn of 2019, just before, so shortly before we went into the pandemic. And at the time, our focus was on safeguarding in the sector in light of the high profile cases of Save the Children and Oxfam. So that we were highlighting at that point a number of cases, including those of the Essex Islamic Academy, the inquiry into Birmingham Diocesan Trust, and others of similar nature. If we return to 2021, we're beginning to see cases that are less focused on, if you like, the urgency of the pandemic again, and returning perhaps to some of the previous themes, including governance in faith charities. And I'll come back to that, I think. One topical inquiry report during the pandemic period was the inquiry into Kingdom Church of Great Britain, a regulatory compliance case opened in 2020, prompted by allegations in media reports that the charity was selling a quote, plague protection kit, which it was claimed would cure and protect against the COVID-19 virus, and led to liaison with Southwark Council and wider concerns about reporting. As a result, the Commission launched a statutory inquiry in August 2020, which is to examine the trustees' compliance with their legal duties and the way in which the charity had a relationship with a connected organisation called Bishop Climate Ministries, which the charity has said was responsible for the sale of the plague protection kits. Other interesting inquiry reports include an official warning issued in June 2020 to Islamic Centre of England, which highlighted two incidents at the events of the charity where a speaker was used, and there was a risk of the charity being associated with a speaker who may have committed an offence under Section 1 of the Terrorism Act 2006 for glorification of terrorism, which falls within the scope of encouragement of terrorism. And the trustees did not comply with regulatory advice and guidance issued to them by the Commission under Section 15(2) of the Charities Act 2011. It's worth noting because the power has only existed for 3 years, as the power to issue an official warning has not been very frequently used. Three of the more notable reports during the past year then concern the ways in which trustees handle various employment and safeguarding issues, with the Save the Children report in March 2020 being particularly notable, with its allegations of harassment and the suggestion that if a charity does not meet the standards the public rightly expect, it does not only let down potential victims of harassment, it also risks undermining support for the work the charity has been established to do. When mismanagement occurs at a charity that is a household name, it risks undermining the work of other charities who rely on public confidence and goodwill to thrive and prosper. So there's a focus there on organisational culture within charities, and the report detailed 5 broad recommendations, including in that case the recommendation that the diversity of the very committed staff team could be improved. There's also the Mary Stokes International case in relation to the process and recording of their decision on CEO remuneration. We're expecting a report on senior executive pay still, I think, from the Charity Commission. There's another report in relation to the Alzheimer's Society where, in contrast to the other two, the Charity Commission found the trustees acted in line with their legal duties. that case, the case of the Alzheimer's Society has been opened in the early part of last year after the national media reported allegations about the handling of bullying and harassment within the charity, including the use of confidentiality clauses in settlement agreements. After reviewing detailed records and information, the regulator found no evidence that those confidentiality clauses used by the charity were designed to or would have had the effect of preventing staff from reporting any whistleblowing, bullying, harassment or discrimination complaints. And allegations reported in the national media around the amount of money paid out in settlement were not substantiated by the evidence that the Commission saw. It's worth highlighting this one though, because those issues continue to be raised in the charity sector press. So there continues to be quite hard scrutiny of the use of confidentiality clauses and the appropriateness of that use. So again, if you're advising charity clients on the termination or management of employment claims, it's worth considering both how any confidentiality clauses are being used and whether there is a wider policy on the use of such clauses for the organisation, so that if questioned later, they're able to both justify the specific use and put them into a wider framework, demonstrating that the use of such provisions or other confidentiality arrangements do not form a way of avoiding scrutiny of decisions made, of proper decisions made. All of the inquiries I've just mentioned and rattled through quite quickly were major inquiries into large and complex organisations, which emphasise the challenges involved in getting the right balance around governance in such organisations. There are also a number of other interesting cases in a sort of more discrete level. One of those was a look at the relationship between charities and their trading subsidiaries in the National Rifle Association inquiry. Decision was published in February 2020, and which looked at the way in which the shooting done by the subsidiary of the National Rifle Association related to the charity's objects of recreational shooting. And the Commission considered that the subsidiary's activities had only the most tenuous, if any, connection with the NRA's charitable purpose of promoting the efficiency of the armed forces for the defence of the realm. The relationship with the subsidiary, which appears to have demonstrated some of the common issues encountered where the independence of the trading subsidiary stops being rigorously maintained. The Charity Commission found that it was not clear to members of the charity or the public how the two organisations were separate and independent due to their overlapping activities. It was unclear how conflicts of interest and loyalty were managed, as the charity's CEO was the trading subsidiary's only director and decision maker. So there's a reminder of that need to ensure that where a charity has a trading subsidiary, or more than one trading subsidiary, that the relationship between them is carefully managed so that they can each be seen to make decisions on their own account, that their activities are clearly separated, and that members of the public can see that separation as well. Moving on, in July we saw an inquiry into the Wimbledon and Putney Commons conservators, the core issue being whether a qualified surveyor's report, that is a report, as many of you will know, on the value of land that is about to be disposed of, whether that was obtained. Now, the question wasn't new, but the case highlighted the reputational damage that failures to obtain a qualified surveyor's report can give rise to, even where, as in that case, the Commission concludes that it's not clear that any loss was suffered. So what you have there is the situation where a charity is disposing of a piece of property and should be getting a qualified surveyor's report because it's one of the categories of disposal that falls within that requirement under the Charities Act, and fails to do so at the right time or fails to consider it appropriately. And even in a scenario where the Charity Commission concluded that the sale was nonetheless at an appropriate value, there's a real risk of reputational damage. So it's an opportunity to have another look at that issue and make sure that charities that you might act for or be involved with are aware of the need to get a qualified surveyor's report, which might include ensuring that they're aware of what a disposal for that purpose looks like, and that, for example, surrendering a lease might amount to a disposal. We'll come back to this context, by the way, this issue, by the way, in the context of the Charities Bill, but let me come back onto that. Okay. And then looking at these inquiries, perhaps the most significant of the past year was the inquiry report and regulatory alert in June 2020 in relation to the RNIB, the Royal National Institute for the Blind. The Charity Commission issued on 25th of June a regulatory alert to all leaders of large or complex service providing charities and an inquiry report into the RNIB specifically. The inquiry had arisen following safeguarding concerns at the charity's Pears Centre for Specialist Learning, which is a school and children's home. And they related to governance failures resulting in the closure of the centre and the forcing the sale of the property for £16 million less than the cost of its development. Whilst the alert was put out to all charities having the profile of an income over 9 million, governed by a board of trustees and run by a separate group of executives and delivering services, the risks identified in the alert were not limited to those sorts of charities, and it's worth taking a note of for almost any charity you work with. And while it's not mandatory for any charity to adopt a governance code, the regulatory alert did refer all of the 600 charities to the charity that it went out to the Charity Governance Code, recommending that they consider whether they should seek to comply with it. And it's well worth considering that again in relation to charities that you may have contact with. We'll come back to a more recent refresh of the code, but in general, we're looking at the fact that if a charity is seeking to bolster the trustees' oversight of the charity, to enhance its governance structures, or simply to continue an ongoing process of ensuring good governance, the Charity Governance Code can provide a good structure to guide charities through that process. In this case, in the RNIB alert, the Commission's language was stark, describing its investigation as lifting the lid on a metaphorical can of worms into the charity's affairs and revealing comprehensive failures in governance that place the safety of young people in its care at risk. And there are a series of detailed findings that I'm not going to go into here, but the governance review made over 30 recommendations, including simplifying the group structure and relationships, reducing the size of the board and rationalising membership agreements, and ensuring compliance with the Charity Governance Code. The RNIB itself issued a detailed statement acknowledging that the inquiry had been a humbling and sobering experience, accepting the Commission's recommendations and highlighting the process, the progress they'd made with implementation. And as I mentioned, an alert went out to quite a number of charities seeking to encourage them to ensure that safeguarding should be a priority for all charities and to consider the wider the governance failings in their own context. Helen Stevenson, the Charity Commission's chief executive, said a catalogue of serious failings were allowed to occur because the charity's governance was simply too weak for the trustees in charge to do the job that the beneficiaries needed them to do. And the NCVO has subsequently issued helpful guidance, a key point of which is that it remains important for trustees to review their operations regularly and to ensure that their charity has a suitable governance structure and systems and robust arrangements for reviewing those structures and systems regularly. So again, if you're working with charities, it's worth considering how often they review their governance and how they do that. So moving on from inquiry reports, it's worth touching on some of the case law that emerged during the past year. And the first thing to say here is that it's been an unusually good year for Supreme Court decisions that are relevant to charities. And those that I'd want to highlight without going into enormous detail are first of all the SIF case, so the decision of the Supreme Court on the Children's Investment Fund Foundation case. Can we have the next slide, please? That's the case referenced by some of these press reports. And the background to the case was a divorce in which the divorcing parties needed to separate out their interests in a very large charitable foundation with very substantial assets. And one of the trustees and members of the foundation, who was concerned to ensure that it was appropriate to make a large donation from the existing foundation to a new foundation, and in the process it was necessary to consider exactly the nature of the duties held by the members of charitable companies. And in its judgment on the 29th of July 2020, the Supreme Court confirmed what has been a long-standing view held by some lawyers and others within the sector, that the members of charitable companies can owe a type of duty known as a fiduciary duty to the company's charitable objects or purposes. And this is a kind of interesting and important decision, although to an extent it raises rather than answers a number of questions about the duty and its practical implications for charity governance. It's worth acknowledging that it took fairly unique circumstances to bring the issue to the Supreme Court. The case relates to very specific legal and practical circumstances. And for many, it won't come as a surprise that members can't just decide to do whatever they choose to do when making a decision as the members of a charitable company. So, you know, this case itself it is in unusual circumstances, or as Lord Reed put it in the final paragraph of the 73-page judgment, the facts of this case seem unlikely ever to be replicated. But we nonetheless are left with a situation where the fiduciary duties in question are owed not to the charity itself, but to the charitable objects. So we've got that much clear. Members owe fiduciary duties, or may owe fiduciary duties, not to the charity, but to its charitable objects. But that then prompts us to ask questions about exactly what the form of those duties are. And we're then told that the precise form of the duties are shaped by the statutory and contractual framework, so the Companies Act, the Charities Act, and the Articles of Association of the charity. So, for example, a member will not have, and not usually have the same rights to access information as the charity's trustees, so will not have equivalent duties to trustees about using that information in decisions. And if we then turn to well, what are the practical effects of this? I suppose one of the main effects will be where we see internal disputes. And we're seeing an increasing number of such disputes in the current environment, in part because people have been making really complex and really challenging decisions over the past year often in relation to issues that determine the survival or otherwise of their charity, and in circumstances where they may and their colleagues may be under quite considerable personal stress. So we're seeing quite a number of internal disputes. And if you then look at those internal disputes, and if you happen to be dealing with a charity established as a company, then you'll often be in a position where the decision being made is of critical importance to the charity, and will need to try and distinguish between the interests of a member with a strong personal view and their personal view on that, and the interest of the charity and its charitable objects, and seek to separate those out and say, well, do you have duties as a charitable member to the objects, and does that mean that the decision you're making should be different to the decision you might make if you were simply applying your personal views? In short, I think advisors and others will study this judgment in detail, but for now it's raising as many questions as it brings to an end. In October, we then saw another Supreme Court decision, and that was the decision in Agudas, I think it is, the Agudas Housing Association. And and this was a decision where which concerned the application of the Equality Act and the Charities exemption to a small charitable housing association, how it allocated its social housing stock. This is a housing association that aims to alleviate the shortage of social housing among Orthodox Jewish people. And essentially, a woman seeking housing in East London alleged racial discrimination. But the decision went all the way up to the Supreme Court, and at every level, the court found that positive discrimination in this way is a legitimate way to tackle social disadvantage. So Agudas Israel Housing Association was able to continue focusing or providing housing available only to the Orthodox Jewish community, on the basis that this discrimination was a legitimate way of overcoming the social and economic disadvantage faced by a particular community of Haredi Jews in the area. So this was about the means being a proportionate means of achieving a legitimate aim. Then moving away from the Supreme Court and turning to the High Court, perhaps the most obvious decision of the year, the most significant one, was the decision of Mrs. Justice Falk in relation to the Kids Company director's disqualification case. And this was a case, as many of you will be aware, which has been running since 2015, when Kids Company suffered its high-profile collapse, and has since seen a number of separate official reports and a torrent of commentary. What we saw after a 10-day trial at the end of last year was a decision being made on whether or not the CEO, Camilla Batman-Gelish, and the trustees who were in post at the time of the organisation's failure should be disqualified from acting as directors. And in short, Mrs. Justice Falk decided that they should not be disqualified, and that the CEO should not be treated as a de facto director, should not be treated as having behaved as a director and acted as a director, and therefore being in the position of being treated as a director and then disqualified from acting as a director for the future. And Mrs. Justice Falk made a particular point to mention both the invaluable work that trustees do for charities, often on a voluntary basis, recognising that the charity sector depends on there being capable individuals with a range of different skills who are prepared to take on trusteeship roles, and that it's vital that the actions of public bodies do not have the effect of dissuading able and experienced individuals from becoming or remaining charity trustees. But she also reviewed in detail the activity of the charity trustees and concluded that they had acted carefully in that role, and that the CEO, let's say, was not a de facto director. And many in the sector will welcome this, reassertion of the value of voluntary trusteeship, and the fact that the regulator said that there was even a suggestion in the judgment that the Charity Commission should be the regulator dealing with cases like this, rather than the Insolvency Service, because the Charity Commission has the most appropriate expertise. But it does leave us with lots of questions about what should be done about the high-profile difficulties with governance that the charity had prior to its collapse, including, for example, the approach to reserves, where it had been repeatedly warned by its auditors that there was a need to have a more robust reserves policy, and perhaps an over-reliance on funding from central government. There was a succession then of more specific cases on particular narrow issues, but I think we can pass on those, except to observe that there was an interesting reminder in Bizrat v. Kabedi, that of the fact that the duty of members of a charitable incorporated organization, a CIO, is actually set out explicitly as to exercise the powers that the member has in that capacity in a way that the member decides in good faith would be most likely to further the purposes of the CIO. So this was about a case involving a long-standing internal dispute between two factions of a church. And there was a suggestion that the members had elected representatives to one of the charity's governing bodies, but that vote was invalid because it was all done because of a campaign by the claimants and without exercising the individual judgment of the members concerned. And the court refused to declare the vote invalid because there just wasn't enough evidence to support the conclusion that the members had breached their duty. And in doing so, the court clarified that the duty is, firstly, for members to act in the way they subjectively believe will be the best for the CIO, and secondly, requires members to exercise their independent judgment. And this part about independent judgment isn't something that's set out in the legislation, so that's particularly interesting. And this is probably the appropriate place to also reflect on the fact that in the last couple of weeks we've heard in the Queen's speech that the government will be bringing forward a charities bill implementing the recommendations, or most of the recommendations, of the Law Commission in its report on technical issues in charity law. That review was published in 2017, and these are largely changes that are matters of detail, matters of evolutionary improvement to the governance of charities, which include equalising, levelling the playing field for changing purposes or amending governing documents, so making it easier to understand what the rules are without those rules for changing a charity's governing documents changing depending on what type of legal status they have. The bill will also introduce some additional flexibility for using permanent endowment, so that's funds or property held on trust for very specific purposes, and there will be some new rules on making that easier. There will be removal of legal barriers to charity mergers, and of note for some, and as mentioned earlier, there'll be a removing or some more flexibility about selling land and where you can get the advice that you need when doing so, as well as some various other minor changes, including minor but important changes, including, for example, improving the use of the charity register, so charity merger register, and enabling it to work as intended, even where there is a will that says, I want to give funds to this, give my gift to this charity, charity A, but if charity A doesn't exist at the time of my death, then it'll go to charity B, where what had happened was that in those circumstances, charities that had ceased to exist but had registered with the merger register were losing out on gifts because they had ceased to exist officially by the time the gift was made, and therefore the gift was going to the backup charity specified in the will. If the charities bill goes through as proposed, what will happen is that will be fixed, and the effect of registering with the charities, the register of mergers, will be as intended, that the charity can cease to exist, it doesn't need to be maintained as a shell charity, and it will still benefit from the gift. That brings me to the kind of final section, if you like, that I wanted to highlight of the past year, which is, as we went through the year, the slogan "Building Back Better" emerged for a lot of different sectors, including the charity sector. Can I have the next slide, please? And Building Back Better, I think, emerged from the world of international development, and it became a standard description of how we should emerge from lockdown, and got charities really talking about fundamental questions about what they might do next. And unsurprisingly, one of those suggestions, given the financial difficulties charities faced over the past year, has been that there should be more mergers. And the various statistics published through the past year suggest strongly that there hasn't been a sudden flood of new mergers, but there certainly have been some, and we may find that as we begin to emerge from lockdown and emerge from the recession, as we move towards the end of this year and the start of next, that as many people are predicting, there's a greater pressure on charities. And if that's the case, and I think we can expect to see that one of the signs of the new world will be more consideration of mergers and consideration of whether organisations should be considering more active collaboration as well as merger. In this context, it's worth quoting what the Good Merger Index report said about the barriers to merger in the sector, and they identified a series of barriers, including institutional inertia, trustee opposition, a failure to prioritise merger, and the cost and the complexity of the process, including pension liabilities. And then went on to say that the Charity Governance Code nevertheless makes clear that merger should still be an option all managers and trustees should consider if it is a potential way to meet their organisation's goals and obligations to beneficiaries. And mergers are by no means a solution to all challenges or the best option for all organisations, but they should be routinely discussed as an option and can be used strategically to improve the health and impact of organisations in the sector as a whole. So I think we're expecting to see more of those mergers coming through. We're already beginning to see them coming through. And in order to complete the merger process effectively, there's often a significant piece of work involved in both considering beforehand the barriers to merger in terms of, for example, the harmonisation of the objects to merging charities, for example, ensuring that the necessary consents are obtained from the Charity Commission in good time, and considering the basis on which other trust property, including permanent endowment, might be held. So it's worth, I think, considering now whether there is preliminary investigation work or preparation required to help organisations understand whether merger is a viable option and, of course, whether it is the right option for them. There's also a key concern around equality, diversity and inclusion. And this is not a new concern. We can highlight changes since as far back as 1993, when the Third Sector magazine reported in a piece called The Great, the Good and the White, that only 2% of voluntary organisations in England and Wales had a black trustee. Or the 1995 book by Andrew Hind, The Governance and Management of Charities, where he concluded, one is forced to conclude when faced with the evidence that the voluntary sector has to do better. And what we are seeing is that there are quite a number of organisations that are actively reviewing their ability to improve the diversity of their board and of their membership. And those raise really important questions in terms of governance, not least because there is often internal disagreement about the speed at which such changes should be made and complex decisions to be made about how to create real change without undermining the culture of the organisation. And this is all emphasised in the refreshed Charity Governance Code that was published in December 2020, which sets out a 4-stage plan for addressing EDI that requires assessing the current level of understanding, thinking about why EDI is important for the charity, and then 2, setting plans and targets, 3, monitoring and measuring progress, and 4, publishing the charity's progress in meeting those targets, including challenges, opportunities, and lessons learned. And then there are 2 wider sections mentioned there. Climate change. A number of organisations, in looking at the way forward, have recognised we know that this is an increasingly urgent issue, and we're seeing developments including an open letter to the Charity Commission from a group of charities seeking to clarify their duties and the extent to which the charities must consider their objects when engaging in investment, an opening on the of a consultation on that issue by the Charity Commission, and a legal challenge from Ashton Trust seeking an answer to it. So I think we will see more in that space. And then in relation to transport, we're also seeing organisations actively considering their use of offices in the years to come, and whether that is an opportunity to encourage staff to consider getting to those offices in different ways, in ways that would again interact directly with climate change as well as health and air pollution. So a number of build back better points there. And I hope that was a bit of a canter through the various issues, but I hope it's been of some value. And if there's anything that you expected us to address that I haven't managed to get to, please feel free to get in touch. Remind me that I said this, and I'm very happy to discuss them with you. Jo.
Thanks, Shivaji. Yes, if anyone does have any questions for Shivaji immediately, please do feel free to pop onto the conversation now or pop something into chat. As I said, we will follow up with a copy of the slides in the next few days. Shivaji and his colleagues are very experienced in the sector, so if you are a member of VWV Approach, do bear in mind that you can make use of the free inquiry service if you're working on something, either as a trustee yourself or in advising a charity client, and you just want to bounce an idea around with the team, do get in touch. Similarly, the team are always happy to look at acting for clients in situations where you might not be able to do so yourself, and those can be passed away in the across in the way of normal referrals. So we'll have a conversation if those situations arise. I know certainly in the last year we've seen a couple of, or certainly a large charity merger that we worked on at a local level alongside some other charity matters that we advised on. So I'm going to ask Emma, my colleague, to pop the poll up now so that you can be providing a little bit of feedback just as I wrap up. And as I said, in terms of follow-up, we will be inviting you to sign up to receive the charity law brief that the team produces, and to be looking out for further ways in which we can help on that front. So if you would kindly complete the poll, and then we'll let you leave, and in a minute or so Emma will bring the session to a close. Thanks very much for coming along. For those of you who've come along, I know some of you are private client lawyers on the call today. Our next VWV Approach webinar is a private client event on the 23rd of June. Finalising the invitation for that, but we're expecting that to cover advising clients with insolvent estates and advising clients who have international assets. So look out for details of that in the next week or so, ready for that event in June. If anyone's got any suggestions for events that they'd like to see in future, please do send us the details.